Hello, we'll be talking about intentional torts for today. Intentional torts has 7 different topics within it. I call it ABC FIT, and the FIT has 2 T's. Assault, battery, conversion, false imprisonment, intentional infliction of emotional distress, trespass to land, and lastly, trespass to chattel. ABC FIT. So I'll be talking about each and every intentional tort one at a time, along with explaining what each element means, because you have to substantiate what the elements mean in order to figure out whether the defendant is liable for whichever tort that we'll be talking about. So let's get into assault. Assault means the intentional placing of reasonable apprehension of imminent harmful or offensive touching of another without consent or privilege. So the elements for assault is very simple. We have the intent, that the defendant intentionally done this act. So we go on to the second element, that the defendant had the intent to place the plaintiff under reasonable apprehension. Element 2. Element 1, element 2. Of imminent harmful or offensive touching. Imminent harmful or offensive touching. That's element number 3. And lastly, the defendant did not have consent or privilege to do that act towards the plaintiff. That is the 4th element here. So, what do these mean? What does all this mumbo jumbo mean? Let's start with intent, because remember, you have to be chronological within your essay or within your simple reasoning in order to understand what assault means and in order to hold the defendant liable for this act. So with intent, we have general intent and specific intent. The defendant either could have had one of those 2 things. I talk about intent within one of my videos. One of my first videos that I've ever posted is about the intent and the actus reus. So I highly recommend you to look at that video in order to understand what the element of intent really means. Reasonable apprehension is pretty straightforward, which means that the plaintiff reasonably knew, was aware of the act that the defendant was going to put on him or her. Fear can be an example of what reasonable apprehension is. That the defendant had the intent to put the plaintiff under reasonable fear. Of imminent harmful or offensive touching. Pretty self-explanatory with the 3rd element here, that the defendant had the intent to harm or offend the plaintiff. Moreover, the defendant did not have consent or privilege by the plaintiff to do that act. An example of an assault is, let's just say that A wants to punch B. B is aware of what's going on between the confrontation he's having with A. And A happens to attempt to punch B. And B happens to duck in order to avoid the harmful or offensive touching that D wants to place upon him. That technically is an assault. Because although A did not actually punch B, it still fit the elements because A had the intent to cause reasonable fear of imminent harm towards another, which is A, without A's consent or privilege. Therefore, A could be liable for an assault. So the defendant doesn't actually have to touch the plaintiff, just as long as the defendant had the intent to cause the plaintiff fear, and the defendant had the intent to use that fear in order to cause the imminent harmful or offensive touching without the consent or privilege of the plaintiff. So let's get into battery. Battery is pretty self-explanatory. It's very similar to assault. So the elements are still there. Okay? We have the intentional harmful or offensive touching of another without consent or privilege. So I'm going to underline the elements again. We have the intent, the intentional act, element 1. Harmful or offensive touching. Example, punching the person or highly offending that person. Without consent or privilege. The defendant did not have the consent or privilege from the plaintiff to commit that act. So those are the 3 elements to think about when you are explaining whether or not the defendant is liable for battery. Analyzing each element is going to be very important, because if you don't satisfy all the elements, you can't hold someone liable for a battery if they did not satisfy each and every element, right? So if the defendant didn't have the intent to cause the plaintiff injury, then you can't hold that person liable for battery. So proving each and every element is absolutely critical in any tort, in any crime you may do, right? Whether it's in torts or whether it's even in criminal law, you have to be able to prove every element. So an example of this, I put it under here, is a sub point that I put here, is items intimately to the body. Intimately to the body. The key word here is items intimately to the body. An example is the defendant snatching a marker out of the plaintiff's hand. So let's just say that I go up to my professor, and without him even knowing that I wanted to do this act, I take the marker out of his hand intentionally with the intent to cause him harm without his consent. Because the marker is so intimately close to his hand, to his overall body, to his person, it acts as an extension of his body. Therefore, me taking the marker out of his hand, that constitutes a battery, although I did not actually touch his physical body. Because the marker acts as an extension of his body. Even an example of, let's say the defendant wants to take a purse from a woman. The purse is so intimately close to the woman's body, therefore the purse acts as an extension of her body. Therefore, if the defendant tries to snatch the purse from the woman, the defendant could be liable for battery. That is what battery is all about here. Remember, the 3 elements must be proven, must be showed in your analysis in order for the defendant to be liable for this actual act. So let's move on to conversion and then false imprisonment. I'm going to erase all this. And also, a battery can also be simply A, punching B across the face, B, kicking B. That is an example of a battery. Your simple fight that can happen is battery. Again, it's a conversion. So conversion means the intentional wrongful dominion over another's chattel without their consent or privilege. So again, I'm going to underline every single element here. So the first element is intentional. That's going to be a common element for all 7 intentional torts. Wrongful dominion over another's property, another's chattel. Okay? That is going to be element 2. Because you need to show that not only does the defendant have wrongful dominion, wrongful possession of that item, you also need to prove that the chattel belonged to another person, that the chattel belonged to the plaintiff. Moreover, you need to prove that there was no consent or privilege So the defendant did not have the right, the permission, the privilege from the plaintiff to grab hold and take that item. An example of conversion is, let's just say the defendant wants to pop the plaintiff's tire in the presence of the plaintiff because the defendant is angry at the plaintiff. And when the defendant gets his pocket knife to pop the tire, that chattel technically belongs to the plaintiff. However, because the defendant destroyed that chattel which belonged to the plaintiff, which belonged to another, remember the element here, to another chattel without consent or privilege, because the defendant did not have the consent or privilege from the plaintiff to puncture the tire. Therefore, the defendant will be liable for conversion and also the full fair market value of whatever that tire may be worth at the time of the act. Moreover, another example could be that, let's say that my friend Riley wants to borrow my car and he steals it. And he happens to, well, not steals it, I meant to say that Riley borrows my car, give him permission, and he sells my car without my permission. He borrows it, however, he sells it without my permission, without my consent or privilege. So Riley intentionally has done the act by wanting, he had the intent in his mind to sell my car. He had wrongful dominion over it because I did not give him dominion over my car to sell it. I just let him borrow my car, not to go ahead and pawn it off so he can get money from it. Moreover, another chattel, pretty self-explanatory. The car belonged to Sam, belonged to me, not to Riley, and he did not have the consent or privilege to sell my car. Therefore, Riley could be liable for conversion under this tort. So let's get into false imprisonment. We have ABC down, assault, battery, and conversion down. ABC is fulfilled. Now we got to get into exactly what fit means. We have false imprisonment. I'm going to go one step at a time. So false imprisonment. False imprisonment means the intentional, physical, or psychological confinement or detention of another for any period of time without consent or privilege. So again, we have certain elements that we have to prove. So we have the intent. As I said, this is going to be a very common element that will be shared with all 7 torts here, intentional torts. You have to prove that the defendant had the intent to do the act. Moreover, there must be a physical or psychological confinement. An example of a physical confinement can be that my friend Emily wants to lock me in the closet. She has the intent to lock me in the closet physically, grabs my body, throws me in the closet, and locks it without my consent or privilege. That is an example of Emily being liable for false imprisonment in a situation where it was a physical confinement, not a psychological one. A psychological confinement is an example is when, let's just say that I get stopped by an officer and he says, "Wait, freeze," and he wants my attention. He tells me to stop. That is an example of me being stopped physically and psychologically without my consent or privilege. So let's keep on going. That's element number 2. Confinement or detention. Basically, interchangeable words. Of another, the plaintiff, for any period of time. This is very, very important. Very, very critical here. For any period of time. So it doesn't matter how long the plaintiff was confined or detained. It could be even a matter of seconds, minutes, hours, or days. It does not matter about how long the length of time was, as long as the plaintiff was confined without consent or privilege, the defendant could be liable for false imprisonment. And of course, this is the last element, element number 4. So showing these 4 elements are absolutely critical. Again, my friend Emily intentionally, physically confines me or puts me in detention within her closet for any period of time. It could be minutes, it could be hours, it could be seconds, without my consent or privilege. That is an example of Emily being liable for false imprisonment. So let's go on to intentional infliction of emotional distress. Okay, intentional infliction of emotional distress is the intentional, outrageous, and extreme conduct that is calculated to cause and does cause severe emotional distress without consent or privilege. So again, I'm going to underline each and every element. So the defendant must have the intent to do it. That's element number 1. And the conduct of the defendant must be, it has to be, outrageous and extreme in order to constitute this element. Element number 2. And the defendant must have the intent to calculate that this extreme, outrageous conduct will cause, number 3, severe emotional distress of the plaintiff without consent or privilege of the plaintiff to do so. So there are 5 elements to think about here. Intent, already explained it. Outrageous and extreme conduct can really vary. It depends. If the defendant knows that the plaintiff is really sensitive in terms of, let's say, having panic attacks, and the defendant does everything in his or her power to trigger the plaintiff's sensitive illness that he or she may have, that could possibly, assuming that the conduct is outrageous and extreme, if the defendant has the intent to do that extreme act and calculates in his mind, remember the intent, to cause the plaintiff harm, the plaintiff must also experience severe emotional distress. I emphasize severe emotional distress. An example that I just said is, let's say the plaintiff has a panic attack and goes to the hospital for 1 week because of what the defendant did. That is an example of a severe emotional distress reaction that the defendant was calculating to happen to the plaintiff without considering privilege. Therefore, the defendant could be liable for intentional infliction of emotional distress. Just an example. The big thing to know about this one is the severe emotional distress piece of it. It has to be severe. So let's get into trespass to land. So trespass to land is pretty straightforward. So we have the intent, same thing. All these intentional torts, we have intent, element number one. The intentional entry upon another's property. So the defendant had the intent to physically enter the plaintiff's property. That's where that entry comes in. Or it could be that the plaintiff is throwing ball. Let's say they're playing volleyball, and the volleyball ends up going across the plaintiff's property, back and forth, back and forth, back and forth. Although the volleyball itself does not enter the plaintiff's yard itself, because of the airspace, because it's going into the plaintiff's airspace of the yard, the defendant could be liable for trespass to land because that's still technically an entry, just in terms of it being in the airspace of the plaintiff's property. So the second element, like I just said, is entry upon another's property. That is element number two. And without consider privilege, very common for each and every intentional tort here, is element number three. So basically this means that the plaintiff did not give the defendant permission to commit an entry upon the plaintiff's property. It has to be a tangible scenario. An intangible scenario will be constituted as a nuisance. And that's a different subject for a different day. However, it must be a tangible situation. An intangible really means air pollution, gas, things like that. A tangible situation is just what I just said. The defendant actually physically entering the plaintiff's yard and or playing volleyball or even shooting guns across the plaintiff's property without the plaintiff's consent or privilege. So lastly, let's get into trespass to chattel. Very simple. If you understand conversion, you will understand trespass to chattel. And remember, proving every element is critical. If you don't prove every element, you're not going to get all the points in your exam. Moreover, you're going to make someone liable for a thing that they technically didn't do, right? So let me write this down. Trespass to chattel. First element is intent. Let me read to you exactly what this whole thing means. So the intentional control over those chattel for a short period of time without consent or privilege from the plaintiff. So we have the intent here. That's element number one that you have to prove. And we need to prove that the defendant has control over the plaintiff's chattel, the plaintiff's property. And when we talk about trespass to chattel and also conversion, it is a situation where we're talking about tangible chattels, movable and tangible chattels, not your property, for example. We're talking about cars, book bags, your laptop, etc. That is what constitutes a chattel here. For a short period of time, element number three, number two, number three, the short period of time piece of it, without consent or privilege. Number four. So an example of this is, let's say that the defendant ends up taking the plaintiff's coat. He has the control, the intentional control over the plaintiff's chattel, the plaintiff's property. And as I said, movable and tangible property. And a coat fits that description. And the defendant has that control over the plaintiff's property for a short period of time without the consent or privilege from the plaintiff. So basically, the defendant made a trespassory taking and carrying away of the plaintiff's property without his or her permission. An example is, let's just say that the defendant takes the keys out of the plaintiff's hand and says that I'm not going to give this back to you until you say sorry to me. And then the defendant throws the keys back at the plaintiff. That is an example of trespass to chattel, because the defendant intentionally controlled the chattel of another, the plaintiff, until the plaintiff apologized, which the plaintiff didn't even give that consent or privilege, right? And the defendant only had a short period of time of holding that item. So the defendant only had possession, control, dominion over that item for a short period of time, rather than a long period of time, or completely destroying it like it would with conversion. Conversion is either destruction of the chattel or the defendant having the chattel for a long period of time. In a situation like trespass to chattel, the defendant has possession of that item belonging to the plaintiff for a short period of time without the consent or privilege from the plaintiff. So I hope I explained these 7 critical intentional torts to you, because this will be really important not only in your law exams, but also important for the bar. So if you have any questions, just comment down below and I will comment back in order for you to understand the material better, because that is the goal of all these videos. Thank you so much, and I hope